I'm Stephen Hicks, Executive Director for the Center for Ethics and Entrepreneurship at Rockford College, and our guest today is Timothy Sandefur. Mr. Sandefur is a senior staff attorney with the Pacific Legal Foundation based in California, and he's an expert on property rights, economic liberty issues, and constitutional issues that bear on those. Mr. Sandefur is here at Rockford College today speaking to the business ethics class on the general theme of market entrepreneurs versus political entrepreneurs and many of the legal and constitutional issues in American political history. So let me ask you, Timothy, this distinction between market entrepreneurs and political entrepreneurs, that was the basis for your talk. What is that distinction?
Well, a market entrepreneur, I would say, is a person who seeks to make a living and pursue happiness by productivity, by creating a product or a service and using the opportunities that the market provides to trade freely with other people who might desire that product or service. Okay. Whereas a political entrepreneur is a person who tries to enrich himself by the use of the state's power of coercion. And that means a person who tries to obtain monopoly privileges or to use licensing laws or other legal restrictions on competition. I often say that Walmart, for example, could make itself a lot richer by making Targets illegal. And to do that would be political entrepreneurship as opposed to the economic entrepreneurship or the market entrepreneurship of selling products and services that people want for prices that they're willing to pay.
Okay. Now, in American economic history, there always have been market entrepreneurs and political entrepreneurs, but you put American economic history in a historical context, talking about an evolution over the course of the last 2 centuries plus, from the economy being centrally based on market entrepreneurship to an increasing role for political entrepreneurship, or an increasing dominance of political entrepreneurship in the context here. And a number of legal issues and political issues were central to the story that you were telling. One of the central elements was this issue of the priority of liberty or democracy in American politics. How does that the decision whether liberty is primary or democracy relate to that set of issues?
Well, that's a big question.
Yes.
To put American legal history into a simple narrative could be very misleading. So it can only be done in big, broad brush strokes. But I think that over the course of 200 years, the general trend that we've seen is a society that began organized around, in principle at least, organized around the individual's right to pursue happiness without unreasonable interference by other individuals or by the state. Okay. And gradually that has transformed itself into a society where government is basically seen as the orchestrator of economic and business activity in the country. Mm-hmm. And the reasons for that are philosophical. Largely, primarily, in fact, today, the effects that we see today are primarily the result of the progressive movement, which began in about 1880 and led until, well, I would argue that we're still living in the progressive era. And the political principles that the progressives believed in and imported into American law are responsible in large part for the expansion of government interference in the market, government deciding whose business should prosper, whose business should not prosper, how property should be rearranged and adjusted to meet the changing needs of the day, to quote Justice Louis Brandeis, a leading progressive. The idea that government acts as a kind of gardener or sculptor who shapes society to be what political leaders believe it ought to be. And as that principle became primary in American political and legal in the legal arena, what you see as a result of that is, naturally, people respond to that atmosphere by investing their time and energy to persuade the government to give them the favors, right? If the government is in the job of deciding who's going to prosper by handing out licenses or imposing tax burdens on people or imposing restrictions on businesses and things, people are going to fight amongst themselves for the opportunity to use that power for their own benefit. And so really what you see is that the trend from market entrepreneurs to political entrepreneurs is largely a consequence of a philosophical change that has taken place primarily in the 20th century.
Okay, so would you then say, again, with painting broad strokes here and all the allowances necessary, that for the first century in American economic history, the dominant view was that government's job was to protect individuals' liberties. And the Constitution, for example, had a number of restraints on democracy, and that was its primary purpose.
Exactly.
But by the time we get to the beginnings of the progressive era in the 1880s, there's been a shift there. That the job of the government is to do what democracy wants, that is to say, its majority rule is given primacy over protection of individual liberties, and so then it becomes a matter of who is most effective at wielding or influencing the government and the government's majority power.
That's exactly right.
Marketplace. Okay.
That's exactly right.
Now you mentioned progressives. You mentioned some progressive intellectuals such as John Dewey, right, in your talk, and also progressive jurists, and with some qualifications, Oliver Wendell Holmes was here. And Louis Brandeis in the next generation, I believe, also was a key figure here. So from the 1880s on through the early part of the 20th century, there's an increasing dominance then of progressivism, and then we add to that in your narrative the cataclysm of the Great Depression. In what way did the Great Depression in effect cement the progressive philosophy in American economic life?
Well, that's a very big question.
Sure.
It starts out with if you contrast the American founders' view of the role of government with our own view today of the role of government, the American Constitution begins by declaring explicitly that liberty is a blessing.
Okay.
The Declaration of Independence says explicitly that we are born with liberty and we create government in part to protect liberty. Okay. And when it violates that right, then we can overthrow the government if we have to in order to change it and protect our liberty. Contrast that with today's perspective, which holds that liberty is basically whatever the government allows us to do. Rights are permissions that are given to us by the society as a whole for society's own purposes. And that shift was done. That shift was made by progressive era philosophers. Now, John Dewey, Oliver Wendell Holmes, Louis Brandeis, and other intellectuals of the period. You can debate whether they should be called progressives or not, but they were pragmatists philosophically, and politically they supported the progressive era movement, which was designed around expanding government control over individual rights. In fact, overthrowing the concept of individual rights and replacing it with government centralized planning in terms of giving people rights or taking those rights away to meet the changing needs of the day. Mm-hmm. Now, that was a gradual progression from the 1880s to the 1930s or so. But it became a very prominent element of the legal academy, of the philosophical academy, until by 1934, in a book called Contemporary Political Thought by Francis Coker, who is, I believe, a Harvard professor. Coker comes out and says hardly anybody believes that there are such things as individual rights anymore, and everybody believes that government exists to control what goes on in society. And that shift was done by the progressives, and it was done in various terms, the most important one of which was the idea that rights are not natural rights. They're not something that we are entitled to because we are human beings, but they belong to us because of our membership in society, and society can control, stretch, or destroy those rights to meet to serve the interests of the majority in society.
All right, so we have a 50-year transition period philosophically from the 1880s to the 1930s, and then we start then to see landmark legal cases kind of instantiating that new philosophical outlook. In your talk, you have two broad categories of economic impact, one involving occupational licensing, the other involving price fixing types of issues and other economic types of controls. Just one or two in each category. What would you take to be the most significant Supreme Court cases in each of those categories?
Yeah, well, the New Deal era, the decade of the 1930s, which I believe the poet Yeats called a low, dishonest decade, saw a dramatic shift in American law that some historians have characterized it as the shift in time that saved nine, is the famous phrase. And it's often said that, well, in 1936 or 1937, the Supreme Court dramatically changed how it understood the nature of economic rights and private property. That is really an oversimplification. What happened was that beginning primarily, I would say, in 1934, you saw the court increasingly adopting these very broad, watered-down interpretations of constitutional clauses that allowed the legislature carte blanche to do what it wanted. The case that I focus on primarily is Nebbia versus New York in 1934, which upheld a New York law setting a minimum price for the sale of milk. And it was in that case that the court abandoned the old legal theories that it had used in protecting businesses against abusive regulation, and instead adopted basically a anything goes attitude that they call the rational basis test, and that still prevails in the law today. And under the rational basis test, laws are virtually never held to be unconstitutional, and this test is what is applied when it comes to economic rights or private property rights. There was another 1934 case called Home Loan Association versus Blasdell, and in the Blasdell case, what the court did was it basically washed its hands of a very important clause in the Constitution, the Contracts Clause, which says that no state may infringe on the obligations of contract. In the Blasdell case, the state of Minnesota passed a law that just unilaterally extended the period of time for redeeming mortgages because there were a lot of foreclosures going on in the Great Depression. So this law was passed. Well, this is one of the main reasons the Constitution was written, was to stop laws like this. I mean, if you look at the history of the Constitution and the Shays Rebellion that inspired the writing of the Constitution in part, it was because of laws like this that were depriving creditors of their opportunity to get back the money that was due to them. So Minnesota passes this law, goes up to the Supreme Court whether this is constitutional, and the Supreme Court said, well, the Contracts Clause doesn't mean today what it meant in the olden days. And if the founders had known about the Great Depression, they wouldn't have written that clause anyway, and so it's okay. And so you have really the finest example of living constitutionalism, as it's called, which really consists of blasting large holes in the Constitution and eliminating constitutional clauses that get inconvenient.
Okay.
And so I think what Justice Sutherland, one of my heroes, Justice George Sutherland, he dissented in the Blasdell case, and he said, if we do not uphold the Constitution when it pinches as well as when it comforts, then we might as well throw the thing in the fireplace. Well, what you see in the New Deal era is the triumph of progressive era thinking that really is alienated from the Constitution, has nothing to do with the classical liberal principles of the Constitution. And that required large parts of the Constitution to basically be rendered null and void. And so the due process of law clause, the public use clause in the Fifth Amendment, the no impairment of contracts clause, the Commerce Clause gets completely revised. I mean, you find the Constitution dramatically altered during the period of basically the 1930s.